Hello and welcome. I'm Amritanshu Rai and you're watching Law of the Land on Raj Sabha TV. Today we bring to you the Protection of Children from Sexual Offences Bill. The bill for the first time seeks to create a legal framework to address sexual offences against children. To discuss the issue, I have with me Inakshi Ganguly, Co-Director HUC, Centre for Child Rights, and Aparna Bhatt, lawyer. Now for the headlines. The bill makes illegal using a child in sexual acts or other types of pornographic representation. This is for the first time that the government has come up with a legal framework to protect children. The bill provides for special courts to deal with such offences but leaves out provision for relief and rehabilitation of victims. National Crime Records Bureau reveals an increase in sexual offences against children. The Protection of Children from Sexual Offences Bill 2011 seeks to protect a child from offences of sexual assault and harassment. It makes illegal using a child in sexual acts or other types of pornographic representation. The bill provides for special courts to deal with such offences but leaves out the provision for relief and rehabilitation of such a victim.
In a recent petition, an NGO, Bachpan Bachao Andolan, had reportedly said that around 1.17 lakh children in India have gone missing over a period of 2008 and 2011 and are believed to have been subjected to trafficking for begging, child labour and prostitution. According to data of National Crime Records Bureau, more than 53% of children are subjected to sexual abuse. In order to provide a legal framework to protect children from such vulnerability, the government proposes Protection of Children from Sexual Offences Bill. The bill defines the parameters of abuse and provides penalty measures.
We must welcome this initiative because there was no specific law to deal with this serious problem, especially when it comes to the relatives, parents, caretakers of children. Then it becomes much more serious. And unfortunately, most of the sexual abuses and assault are committed by the close ones, including the relatives or the teachers.
According to the bill, any person below the age of 18 years is defined as a child. It seeks to penalize any person who commits offences such as sexual harassment, sexual assault, penetrative sexual assault, and aggravated penetrative sexual assault. Person using a child for pornographic purposes or exposing him to any form of media in an obscene manner will be considered guilty. The bill also includes penalties for storage of pornographic material and abatement of an offence.
It has not taken care of the non-criminal aspect of the issue of the child being rehabilitated properly. So in that sense, I think this bill is really lacking, that it does not take care of the protective measures that have to be taken to see that the process of adjudication itself is a process of healing.
The bill includes assaults by staff of private hospitals, educational institutions, even the offenders who are in any kind of relation with the child. The punishment of these offences will vary from 3 years and can stretch up to 8 years with or without fine. The bill also includes penalties for making false complaints. The special courts will be empowered to take up complaints from local police or from special juvenile police unit.
And this whole concept of the concern for 16 to 18 years could be problematic, and it can be exploited by people who have actually perpetrated the crime against a child in that age group.
According to a report sponsored by Women and Child Development Ministry, parents, relatives, persons known to the child or in a position of trust and responsibility were mostly found to be the perpetrators of child sexual abuse. Many of the cases remained unreported due to social stigma attached with the issue. Also, absence of any law instigated these crimes. Reshma Roy, Raj Sabha TV.
How has the government been dealing with offences that have been happening till now? Ma'am, the first question to you is, what is the law that the government uses to tackle such issues as of now?
At the moment, the government is using the Indian Penal Code. Not the government, I mean the judicial mechanism, the police, the justice mechanism uses the Indian Penal Code, which would define rape, which would define outraging of modesty, which would define similar offences. But it is scattered and it is in the IPC, and that's what they have been using.
Ma'am, a question to you, Aparna. See, has the present existing law that we have, the IPC, does it deal with this specific subject? And if it does not, then why has it taken so long for a legal framework to actually come in so late?
The first question I can answer. Second question I cannot. I cannot say why it has taken so long. As far as the first question is concerned about whether the law covers today, it covers in a very generic sense. There is rape. It is extremely general. But what we have one is known, and when we work with children, and especially children who are victims of sexual abuse and assault, we know that the kind of offences that the children are subjected to cannot be put under the huge umbrella of rape and and the other section that we have now, outraging the modesty of a woman, that those two sections are not adequate to cover it. That is one problem. The second problem is, as you know, we know that a lot of boys are subjected to sexual abuse. Now, these two are not, I mean, boys don't get covered by them at all. So for the boys, we are left with that section 377. And so keeping these in mind and having understood the kind of offences that are perpetrated against children, IPC is not adequate, and this is something all of us we are in agreement with it. That is, there is no disagreement on that. So there has to be a law which makes a very clear, comprehensive and also specific.
Right.
To be specific, yeah.
I'll get you in, ma'am. See, 18 years is the definition, but the courts have gone ahead and actually said that 16 is the time when, I mean, especially in terms of elopement and other issues relating to running away and getting married and things like that, they've actually said 16 is a good age to accept whatever the child, takes a call on. But this act defines the child as 18. How do you rationalize or balance between that?
This act is defining a child as 18 years, going by the fact that we have ratified the Convention on the Rights of the Child, and the Convention on the Rights of the Child defines a child as 18 years. And this is an effort to harmonize the definition of children, which is not so far there in our laws. You know, at some age is 14, like age of 16, age of working is 14. So, you know, there are an age of sexual consent. If it is marriage, then it is 15.
Yeah.
So there is a sort of, so this was an effort to harmonize the age and bring it to an international standard. Having said that, 18 definite is, to my mind and to my centre's mind, and this is what we have also said at the standing committee, 18 is perhaps not a practical age to keep in a law on sexual abuse. Given the fact that increasingly there is consensual sexual activity that is taking place between younger and younger children. While we cannot have a very low age of consent, at the same time we have to have a practical age of consent. And 16 to our mind seems to be a rational balance.
Is that okay by you, or whatever experience that you've had as far as dealing with the legal aspect of the cases? What should be the acceptable age for definition, for practically defining the child?
See, it's, I think we are kind of mixing up definition of a child with age of sexual consent. They're two different things. A child will be a person up to the age of 18 years, and I don't think there's dispute even within the child rights movement as far as that is concerned. As far as sexual consent is concerned, a lot of us are divided on it, and I'll tell you what are the debates that is cropping up. One school of thought is that since we have agreed that age of 18 is the age of a child, let the sexual consent will also be at that age. That is one school of thought. That is a little conservative school of thought. The second school of thought is that younger people are now getting sexual exposure at a much younger age. So we have to be realistic, as Inakshi said, and then acknowledge the fact that younger people do have sexual exploration, may not really have a proper intercourse, but sexual exploration, and criminalizing one of the participants in that is not a good idea. So that is the second school of thought. The third school of thought, which I come from, is that in every case of sexual interaction of a child, you have to look into both the parties. Now, if you have a 16-year-old child having sexual encounter with a 40-year-old man, I'm not sure how.
I get the point.
These are things one has to take into account. But while it is easy to say that, how will the law factor it? It's a very difficult thing, because then what will happen is it's the discretion of the policeman. It's the subsequently discretion of a judge to understand and apply that, okay, what was the undue influence caused to this child at that point in time to enter into this encounter. So these are some things which has to be addressed. And I think if the government is now looking at a bill, it's late. It's come after a long time, but nevertheless it is coming. This is an opportunity for them to explore this, look at comparative jurisprudence where a lot of people, other countries have ventured into this. They are distinguishing. There is a way in which they look at these sexual offences. When a younger child is exposed to a sexual activity, what was the age of the partner? So there is an age group, there is kind of a 3-year, that kind of a division is made, and it's important to have that in the law.
Defining the parameters of while you're codifying, do you think it's a difficult work? I mean, by simply saying 18 years, and if you need to really qualify it by the various parameters that you both have pointed out, can it be codified or written as, or will it have practical difficulties, ma'am?
It is a challenge, but it needs to be done. As she has said, the definition of the child is different from age of sexual consent. The age of the child is defined as 18, and that's perfect. But now we are looking at practicalities. While we do not want to criminalize consensual sexual activity of any one party who has been involved in the act, we also must make sure that the child is protected from an adult who might have been using the child for other purposes. So in a way, there's a very interesting way in which, as you have also mentioned, there's an aggravated sexual assault. There are
parameters. Those parameters will come into play.
The bill has actually has made an attempt to define different parameters, age-wise, in terms of the kind of offence, in terms of the intensity of the offence. It has gone into making that distinction.
Ma'am, on that note, it's time for us to head into a break. When we come back, we will talk about the child-friendly features which are absent. Welcome back. Most of the cases of sexual abuse against children was dealt under Indian Penal Code, which did not provide a holistic approach to the offence. The parliamentary panel, which studied the bill, recommended that the court investigations and procedures should be child-friendly.
The Parliamentary Standing Committee observed that the preventive and rehabilitative aspects in the bill remained sidelined. The committee observed that sexual offence of any kind not only harms the child physically, but also causes long-term damage to the mental state of the child.
But the enforcement of such a bill is in fact a difficult task. First of all, the children themselves don't come out with the truth because of the social taboo and all kind of problems. They don't have that courage to speak out.
According to the National Crime Records Bureau data, there has been a significant increase in sexual offences against children, which included rape, procuring of minor girls, buying and selling of girls for prostitution is up from 2,265 in 2004 to 5,694 in 2009. Out of total 20,890 reported cases of rape in 2009, nearly 24% cases were found to be against children.
It does not directly include a provision on child trafficking and the entire network of agents and contractors that are involved in this, nor does it talk about child prostitution in that sense of the term. But what it does is that when a person is caught as being an offender, that of a child in terms of sexual assault and sexual abuse, that offender is going to be punished.
India has over 8 million children who work for a living. The threat of sexual violence intensifies as they move out of their confines of home to earn a living. According to the Parliamentary Committee, preventive measures have to be initiated in order to minimize such crimes. The National Commission for Protection of Child Rights, NCPCR, recommends free and confidential counselling and support services for victims.
The bill, in absence of any legislation covering this field, is the first of its kind. After being passed in the Rajya Sabha, the bill now awaits to cross the final boundary of the lower house of the parliament. With camera person Amit Rathor, Reshma Roy, Rajya Sabha TV.
Does the law have any feature which can be called as child-friendly? Aparna.
The law doesn't define child-friendly. That's the first kind of reservation one has about it. And having been involved in a parallel process when this bill was being drafted with the NCPCR, and what one had wanted then and one wanted this bill to include was a huge parallel paraphernalia to support a child through the legal process. Now, I have run a program called Rape Crisis for 5.5 years in Delhi. And we saw a conviction rate increase from 7% to 29% in that 5 years. Not for any other reason, but only because there was a person hand-holding a victim.
Yeah.
Okay, that makes a huge difference. So one wanted that a government creates an infrastructure of that nature. It doesn't cost much. They have a program when we had suggested how to go about it. That is completely missing from it. So you may have very eloquent definitions and eloquent laws and all those things, but if you do not have an implementing agency which is able to be sensitive to that kind of a need that is required, you will have the same situation. Yeah. Unless you bring in an infrastructure which is able to understand the nitty-gritties and sensitivities that is involved, how can you expect it to change? We are not equipping our policemen with better technology and better understanding of the law. It's the same people. And I think it's unfair to expect them to change overnight, to understand that because we have better English now, so there's better definitions, and ask them to, then say suddenly we are child sensitive. I don't think that is a very, I would say that everyone is nursing an illusion which is not going to take place.
Rehab and relief, two very important aspects. Not a word about it in the bill.
In fact, that was one of the comments that we had made to the standing committee when in our presentation to them, that rehabilitation and reintegration is something that is completely missing. You cannot take a child up to a point and say now justice is done. Justice is done only when the child is successfully, to the extent possible, integrated into the community, and there is a process of mental and physical reinstatement that the child feels, and that is completely left out of the bill. That is a very important part of the bill. The other very important part that we feel needs to be thought about at least is the status of the bill as a special law. When any act is a special act, say, it becomes yet one more law, it's yet one more criminal act, law that the policeman has to read. He already has the CRPC, the IPC, the Evidence Act, and you're increasing one more act in the pile of books that he has to read. Think about this in a small, very small thana in some very small village in a remote part of this country.
Implementation never.
There is no way that he is going to be reading yet another special law. He needs to read he will only read the IPC, the CRPC, and the Evidence Act. And one of our biggest requests from the government was that this should be made a part of the IPC. And the only reason that they did not do so, and they have mentioned that in the standing committee, that it takes too long to amend the IPC. Now that is really not a good enough reason, to not do something that is correct. Why should it take so long? If it is required, it has to be done, and it has to be done expeditiously.
Right.
And if the government so believes that this is the best way to implement the law, as Aparna has pointed out, otherwise it will be just a long set of good words, nice English, eloquent English.
I'll get it, Aparna, on the point of the social stigma. Don't you think the judicial system as it exists is an open court system? Whether it be things like rape, witnesses being cross-questioned on rape, or child abuse, everything, it has to be in an open court. Do you think we need to reconsider, especially in terms of child abuse, rape, and similar laws where the trial is happening? Do you think, especially in keeping in mind the social stigma bit?
May I just answer that? I mean, I'm just also requesting you should give me some time to talk about relief and rehabilitation, because I have huge concerns about that. To answer your question now, is that, see, we have in-camera proceedings in all rape cases. So similar things are also going to happen here. But so that there is some kind of attempt to protect the identity of the victim. That is an attempt has been made. But the problem is not that one hearing that she has. The problem is from the time she encounters the law enforcement, that is police. Now, in the FIR, Justice, when one of the judgments of Justice Anand, as far as 2003, 2004, Gurmeet Singh, he had recommended that we should stop referring to a victim's name in the FIR itself, because we access FIRs. FIRs come out in the public domain. So that from that stage onward, there should be protection given to a person from that stage onwards. Unfortunately, that is not happening. So because in the FIR, you write the name, father's name, whatever other details one has to
all
write,
identities
it's all written. It's all there. Again, in all the court documents, the person's name is written there. So somewhere that the beginning of protecting of identity has to commence from the police station itself. Now that has to be provided for in the law, and the law doesn't provide it. And by this act, they can't do it because they have to go back into Evidence Act, CRPC, and they have to start amending
whole gamut
those.
of.
It has to be done. Otherwise, it won't happen. I mean, it's as simple as it won't happen. So it's important to do that. That's the first thing. The second thing is, in an in-camera trial, what happens is, when the child is examined, it's in camera. When her mother comes to talk, it is not in camera.
Okay.
I mean, I would say the entire trial should be in camera, or we should have a mechanism where you have day-to-day trials. You just call the people concerned, finish with them, and then get on to the next one. And these are ways of doing it. It's not as if it is not possible in our country to do it. We can do it. We have the infrastructure. Our judges, some of them are so good, you can't imagine how good they are and how sincere they are. It is possible to do it. But the government, the bureaucracy,
You need
has
to be
put in a
much more
system to be able
sensitive.
to do it.
The approach has to be.
It is not sensitive, Amritanshu. Let's not get mixed up. It is creation of infrastructure. It is setting up a practice. It is very important. I mean, I want to.
I'll come to you in the next segment.
On
It's
relief.
time for us to head into a break. When we come back, we will show you an interview with A. Shivakumar, advisor, UNICEF. Welcome back. My colleague Reshma Roy spoke to A.K. Shivkumar, advisor, UNICEF, and tried to get a perspective into the issue.
How pressing is the problem of child abuse in India?
If you look at the National Crime Research Bureau NCRB data, since 2000, the number of cases of crime against children has increased fivefold, from around 5,000 to over 26,000 in the last 2010 report.
Do you think this bill is effective enough to curb this problem?
The first thing after the legislation has to do with effective implementation of the law. And as many people have really pointed out, it is much more difficult to look at issues of implementation of law when it comes to children than it comes to adults, because by their very nature, children are much more vulnerable, they're weak, they don't have a voice, and so on.
Does the bill talk about the post-incident mechanisms like trauma care, medical facilities, rehabilitation, etc.?
Yes, I think you're right in saying that the bill has focused much more on using law as a deterrent and less actually on prevention, and probably not as effective in terms of suggesting what the rehabilitation and resettlement or rehabilitation mechanisms should be. The National Commission for the Protection of Child Rights, for instance, has suggested creation of a compensation fund. Now, such a fund must be created. The amount of compensation should be specified.
Child trafficking, child prostitution is a big problem in India. Does the bill include any provision on these problems?
My reading of the bill, I have an old draft of it, it does not explicitly talk about child trafficking or child prostitution. And we must also recognize that in many ways, child prostitution and child trafficking are different from child abuse and sexual offense. For one, who is the perpetrator is not very clear when it comes to child trafficking or child prostitution. Having said this, of course, I think it's a very good opportunity to bring some elements of child trafficking and child prostitution into this bill as well.
As an expert, how do you view this bill?
But there are a few areas which definitely need strengthening. One is, of course, as was mentioned, it should not just be about protection, but we should also talk about this bill having certain prevention clauses. It should explicitly and unambiguously recognize a child as a person below the age of 18. If you look at the definition in the old clause, it says under the age of 18, save as provided otherwise.
How do you rehabilitate and provide relief to the victim? Aparna.
You see, the concern is that when you make a law, especially one request was that it be in IPC. Now you didn't want it to be in IPC for various reasons. So now you have a separate law. So that was an opportunity for them to also provide for civil remedies. Now the the incarceration and all those things is there, it's been there forever, it's nothing new in it. When you have to have a new law, have something radical for the benefit of the victim who has suffered the loss in that process. So in that benefit nowadays what happens is the way it is given to her is more of a dole. It's like a benevolence of the government and then you give them some money. It should not be like that. It should be a matter of right. If I have suffered abuse because the state did not protect me, I should be able to claim relief as a matter of right. And that should be given to me in the law. And that has to be put up in the law. And I wonder why they did not do it. It was an opportunity for them.
Right.
There's enough evidence available where every victim needs some kind of a cash redressal compensation to be able to rehabilitate herself. Unfortunately, that is not there in the bill.
Inakshi, the point you wanted to make about including religious institutions.
Yes, I have an old version of the bill, but the Standing Committee has recommended that the religious institutions be included. And the second very important point that the Standing Committee has made is regarding the portrayal of the children in the media, and that there should be under no circumstances, even the guardians should not have the right to give consent. Now, I am not sure if these are two very important points have already been included in the new law, but if they have, then it's really good.
Yes, ma'am. They have, as far as the information that I have, they have been, both of them have been included. Thank you, ma'am, for joining us on this show and discussion. It's time for us to end the show. You can email your suggestions and comments to law.rstv@gmail.com. You can also watch our shows on the YouTube. We'll be back with a new issue and a new episode. Keep watching Rajya Sabha TV.